Hello everyone and welcome to Internet Law Review. For today's story, I have the case of Rimini Street versus Oracle. This is a case dealing with the assignment of damages in a lawsuit. In this particular situation, there was a copyright issue. The copyright statute allows a court to issue fees for the lawsuit itself to a winning party. The statute also provides that a court may provide what it calls full costs. At issue here is whether the phrase full cost also includes the fees for a lawyer or not. In many fees shifting provisions, it specifically calls for attorney's fees where appropriate, but here it simply calls it full costs. So does it include attorney's fees or doesn't it? That's what the U.S. Supreme Court has to decide. Let's read the case and see what they had to say. A jury awarded Oracle damages after finding that Rimini had infringed various Oracle copyrights. After judgment, the district court also awarded Oracle fees and costs, including $12.8 million for litigation expenses such as expert witnesses, e-discovery, and jury consulting. In affirming the $12.8 million award, the Ninth Circuit acknowledged that it covered expenses not including within the 6 categories of costs that the general federal statute authorizing district courts to award costs provides may be awarded against a losing party. The court nonetheless held the award was appropriate because the Copyright Act gives federal district courts discretion to award full costs to a party in a copyright litigation. So we see the general dispute. In the federal law, there is a general statute that says that there are 6 categories of fees that can be awarded to a winning party. But in the copyright statute, it talks about full costs. So does that language only include the 6 categories, or does it contemplate no more? Let's see what the Supreme Court had to say in its finding. Held. The term full costs in Section 505 of the Copyright Act means the costs specified in the general cost statutes. The sections of the statutes define what the term cost encompasses in subject-specific federal statutes, such as the one here. Congress may authorize awards of expenses beyond the 6 categories specified in the general cost statutes, but courts may not award litigation expenses that are not specified in the general statutes absent explicit authority. This court's precedents have constantly adhered to that approach. The Copyright Act does not explicitly authorize awards of litigation expenses beyond the 6 categories specified in this generalized statute, which does not authorize the award for expenses such as expert witness fees, e-discovery expenses, and jury consultant fees. Oracle counter-arguments are not persuasive. First, Oracle argues that the word full authorizes courts to award expenses beyond the cost specified in the generalized statute. The term full is an adjective that means the complete measure of the noun it modifies. It does not, therefore, alter the meaning of the word costs in this particular section. Rather, full costs are all the costs that are otherwise available under the relevant law. Second, Oracle maintains that the term full costs in the Copyright Act is a historical term of art that encompasses more than the costs listed in the generalized statute. Oracle argues that Congress imported the meaning of the term full costs from the English copyright statutes into the Copyright Act in 1831. Oracle contends that the 1831 meaning of full costs allows the transfer of expenses of litigation beyond those specified in any cost schedule and overrides anything else Congress enacted in the Fee Act of 1853 or subsequent cost statutes. Courts need not, however, undertake extensive historical excavation to determine the meaning of a cost statute. In any event, Oracle has not shown that the phrase full cost had an established meaning in either English or American law that covered more than the full amount of the cost that would be listed in the applicable cost schedule. Case law since 1831 also refutes Oracle's historical argument. Third, Oracle advances a variety of surplus arguments. According to Oracle, after Congress made the cost award discretionary in 1976, district courts could award any amount of costs up to 100%, and so Rimini's reading of the word full now adds nothing to costs. Because Congress would not have intended full to be surplus, Oracle contends that Congress must have employed the term full to mean expenses beyond the cost specified in the generalized statute. But even if the term full lacked any continuing significance after 1976, the meaning of costs did not change. Oracle's interpretation would also create its own redundancy problems by rendering the second section of this statute, which covers attorney's fees, largely redundant because the first sentence would presumably also cover those fees. Finally, Oracle's argument, even if correct, overstates the significance of a statutory surplus and redundancy. Kavanaugh writes on behalf of a unanimous Supreme Court. So our case today is a pretty easy case of statutory interpretation. We're looking to a clause and seeing what it means. In this case, the words full costs. And what does that mean? There's a general section of law that says, in general, here's how to award costs. And of course, specific statutes can either take away or add to that, as is often the case. In this particular statute, they have just the phrase full costs. And so one would assume that that would refer to the generalized provision without more. And as the Supreme Court is fairly right to point out, if Congress intends something more, they have to be a little bit more explicit than just using the word full. If Congress wanted something more than just costs, and by full cost they meant something more, they'd have to be just a touch more explicit in their meaning to override the general statutory construction tools that we generally use. As a result of that, the unanimous Supreme Court decision is not surprising, and I would agree with the interpretation of the court because it does fall in line with general construction canons. But for now, my friends, this is all. I hope you're well. Until later, cheers and goodbye.